This video is for Joshua Miller 79 on Twitter and Joshua Miller 79 on YouTube as well, but is really relevant for anyone who might describe themselves as a constitutionalist or anyone who advocates for what some or many call the rule of law. Mr. Miller has, in his Twitter profile, identified himself as a constitutionalist, and he has advocated for an original intent theory of interpretation of the Constitution in the past. I have already remarked in previous YouTube videos on why I think that the original intent theory of interpretation of the Constitution is, strictly speaking, not possible. But in this video, I would like to discuss constitutionalism as such. Mr. Miller commented that if there is a threat to a country, if there is a real threat to a country, significant enough to justify employing military action against another group of people, then that country should at least make a declaration of war. Specifically, Mr. Miller feels that if Congress is going to fund military action, they are held constitutionally responsible to declare war in order to justify that military action. Or, perhaps said another way, if Congress fails to declare war, then the supposed threat must be de facto not significant enough to employ military action, and that to financially support such military action without declaration of war is, in Mr. Miller's originalist view, a violation of the Constitution. When I considered Mr. Miller's idea, I was struck with this thought. If Congress is duly elected in the manner described in the Constitution, and all other constitutional office holders are also legitimately designated as directed by the Constitution, and we are to accept that those office holders are in open violation of the Constitution, does this not bring into question the legitimacy of the Constitution itself? And to explain this thought a little more clearly, if the Constitution is insufficient in its own supposed checks and balances to control its designated members, branches, or agents, then it would seem that either the Constitution is insufficient or that we are no longer under a constitutional system, that some other system has been put in its place, and that the Constitution is a rulership in name only. I believe one can make this argument in any case that the executive, legislative, or judicial branches exceed their authority or constitutional authority, such that their constitutional authority being exceeded with no control. The Constitution seems, proven by experience then, if such is the case, to either be impotent or inadequate to control its agents, or the other possibility is the Constitution is meaningless and has been replaced by a despotism of the people administering the law. In either case, it seems that the Constitution has, by experience then, been invalidated itself. If it purports to help us get to a rule of law and away from a rule of some men over other men, or specifically in the American Revolution, to get rid of a despot or a monarch that has complete control over the people, and then substitute that monarch's rule for the rule of law, then if there is an agency of the Constitution, and it is a legitimate agency of the Constitution that supersedes its authority, that goes beyond what its legitimate authority would be, then it seems that somehow the Constitution wasn't adequate to control. There wasn't enough checks and balances there. So either the Constitution itself is inadequate, or the Constitution itself is just plainly being ignored. For any person who might consider themselves constitutionalists, I guess I would wonder how you might resolve this kind of problem, as I've stated it. Maybe it's a false problem, maybe it can be dispelled very easily, but it seems problematic to me at least, and so I'm curious as to some responses people may have on this. It seems that you can either say that everything that any constitutional agent does is constitutional, but then that would mean that the Constitution is whatever they say it is. So whatever they say is constitutional, which effectively negates any pretense that our rule of law principle had of being fair or universal. You can do that, or you might be able to save constitutionalism by pointing to the control of its various branches and agents by the people themselves. In which case, the Constitution would seem to have the exact same consent of the governed as any despotic monarch. And I really hardly think that this can be considered like any kind of enlightened governance. And it still doesn't seem to save this rule of law. So, to Joshua Miller 79 or any other constitutionalist, how do you save the Constitution as a document of enlightened governance, which presumably supports this rule of law, if the branches or agents have been shown by our experience of violating their own constitutional limitations? In light of this kind of problem, how can the rule of law be anything but the rule of some people over other people, so long as the law must be administered by people, right? And perhaps a bonus question for you YouTube listeners. If you believe that people have inalienable rights, rights that cannot be legitimately taken away from any individual by any other individual or collection of individuals for that matter, then if an action taken by a government's agents violates an individual's rights, does this not invalidate that government? Or does this invalidate that government? And if the answer is no, if not, if we don't measure the line at one single violation of one single individual's rights, if not, then if that doesn't invalidate the legitimacy of that particular government, where do we draw the line? Except for perhaps, when we draw that line when the state does lose its legitimacy through a violation of individual rights. For if the standard is not a single violation, I'm not sure that any other non-arbitrary standard is possible until you have total despotic tyranny. So you see where I'm kind of getting at, that if governments are violating people's rights, then there is a case to be made, I think, that if governments are situated to protect rights, if they then become a system of violating rights, then doesn't that invalidate our premise? Doesn't that invalidate the legitimacy of that government, even if it's just one individual? And, if you say, well, it has to be 1,000 or a certain percentage of individuals within the society, well, then we're just getting back to that consent of the governed thing, aren't we? Where eventually, if you oppress the people enough, they'll just rise up and revolt, and that'll take care of the tyrannical despot. But that doesn't seem to be a philosophical, principle, just more of a, reality and, sociology or praxeology type thing, perhaps. Those are just some thoughts, and I'd be curious to know yours. Thank you so much for watching.